Being accused of domestic violence is a terrifying experience that can throw your life into chaos. The consequences, potential jail time, probation, mandatory therapy, and a criminal record are overwhelming. These charges can also impact your employment, child custody, ability to rent a home, firearm ownership, and more. During this difficult time, feelings of fear, confusion, and isolation are common. However, you are not alone. Although Colorado has strict domestic violence laws, you do have rights and there are ways to fight for them. Believe it or not, it is possible to get domestic violence charges dropped or dismissed. If you are facing domestic violence or domestic assault charges in Colorado and don't know where to begin, this post will guide you through strategies for potentially getting the charges dismissed or improving your chances for a fair resolution. What is domestic violence? Domestic violence is defined as a pattern of abusive behavior where one partner attempts to exert control over another. This control can manifest as physical, sexual, emotional, psychological, or even technological abuse. Domestic violence can include actions such as physical abuse, hitting, kicking, choking, or using weapons. Emotional abuse, insults, criticism, gaslighting, or isolating the victim. Sexual abuse, forced or unwanted sexual contact, rape, or sexual assault. Psychological abuse, intimidation, threats, stalking, or destroying property. Domestic violence can happen to anyone regardless of race, age, sexual orientation, religion, gender identity, or socioeconomic background. It occurs in both opposite sex and same-sex relationships and affects people who are married, dating, living together, or sharing children. At our law firm, we are committed to supporting all individuals, including those in the LGBTQ+ community, who are facing domestic violence allegations. The penalties for domestic violence convictions in Colorado. A domestic violence conviction can lead to severe legal and personal consequences. Navigating the legal system alone can feel overwhelming, but it's essential to understand the potential penalties and know that an experienced domestic violence attorney can guide you through this process. Here are the common penalties for domestic violence convictions in Colorado. 1. Mandatory provisions. Colorado law mandates specific conditions for individuals convicted of domestic violence. These often include a mandatory protection order that prohibits contact with the victim, or at the very least prohibits bad contact such as harassment, intimidation, or molestation. This protection order remains in place while the case is pending and often extends through the probation period. Additionally, convicted individuals must attend counseling or therapy, perform community service, and possibly enroll in violence awareness or anger management programs. Violating these requirements can lead to enhanced penalties, including increased jail time. 2. Domestic violence evaluation and treatment. All individuals convicted of domestic violence in Colorado must undergo an evaluation to assess their risk of reoffending. Based on the results, the court may order mandatory domestic violence treatment programs that address underlying issues such as anger management, substance abuse, or interpersonal skills. Failing to complete the required treatment can result in additional fines or further penalties. 3. Fines and fees. Financial penalties are a standard part of a domestic violence conviction. The court will typically impose fines, and the individual may also be responsible for court costs, victim compensation fees, and other related expenses. The amount varies depending on the offense and the person's criminal history, but these fees can put a significant strain on your finances. 4. Mandatory protection order. A mandatory protection order, also called an 18-1001 protection order, is issued in every domestic violence case. It prohibits contact with the victim, which may include staying away from their home, office, or other designated locations. The protection order may also require the accused to relinquish firearms. Violating this protection order can lead to additional criminal charges, including jail time. 5. Jail or prison time. The severity of a sentence for a domestic violence conviction depends on the nature of the offense and the person's criminal history. Misdemeanor offenses can result in jail time, while felony convictions may lead to prison sentences. Some offenses come with mandatory minimum sentences, and felony cases are generally more serious. The court may also impose jail time as a condition of probation. Colorado's mandatory arrest policy for domestic violence cases. Colorado takes domestic violence seriously and has a mandatory arrest policy. This means that if the police are called to a domestic violence incident and determine there is probable cause that a crime occurred, they are legally required to arrest the suspect, regardless of whether the victim wishes to press charges. Although this policy is intended to protect victims, it can lead to arrests based on minimal evidence. However, the case can still be dismissed later if the prosecution determines there isn't enough evidence to move forward. That's where an experienced defense attorney comes into play. Can domestic violence charges be dropped? One of the most common questions people have is whether domestic violence charges can be dropped, particularly if the victim recants or asks to have the charges dismissed. The short answer is no. Only the district attorney can decide whether to drop charges, even if the victim no longer wishes to pursue the case. However, with the help of a skilled criminal defense attorney, there are ways to challenge the prosecution's case and potentially get the charges dismissed. Insufficient evidence. The prosecution must prove your guilt beyond a reasonable doubt, and if they lack strong evidence, your lawyer can argue for dismissal. This can involve questioning witness credibility, pointing out inconsistencies, or highlighting the lack of physical evidence. Challenging the evidence. If law enforcement violated your rights during the investigation, such as conducting an unlawful search or seizure, your attorney may be able to suppress that evidence, which weakens the prosecution's case. Identifying inconsistencies. Even strong cases can have weaknesses. Your attorney will thoroughly review the prosecution's evidence and look for inconsistencies or contradictions in witness testimony or police reports. Why victims can't drop domestic violence charges in Colorado. In many non-domestic cases, prosecutors may drop charges if the victim doesn't wish to proceed. However, domestic violence cases are different. Prosecutors understand that the dynamic of domestic relationships often involves dependency, co-parenting, or financial ties. As a result, victims may feel pressured to recant or drop charges, which is why the state, not the victim, decides whether to pursue the case. The policy is designed to protect victims from ongoing abuse, even if they feel compelled to defend the accused. However, it is not without criticism, as it can sometimes lead to further emotional harm for victims or raise concerns about wrongful convictions. How can a criminal defense attorney help? If you're wondering how to get domestic violence charges dropped, a skilled criminal defense attorney can help navigate this complex terrain. Here's how. 1. Legal knowledge and experience. An experienced criminal defense attorney understands domestic violence laws, court procedures, and how to build a defense. They can anticipate the prosecution's tactics and use their expertise to develop a strategy tailored to your case. 2. Investigating your case. A good attorney will conduct a thorough investigation, reviewing police reports, examining the crime scene, and interviewing witnesses to uncover any weaknesses in the prosecution's case. They will look for inconsistencies and challenge the credibility of the evidence against you. 3. Developing a defense strategy. Your attorney will craft a defense strategy based on the facts of your case, reviewing potential defenses, strengths, and weaknesses. A strategic approach can make a significant difference in the outcome of your case. 4. Negotiating a plea deal. In some cases, your attorney may be able to negotiate a plea bargain with the prosecutor. This could involve reduced charges or a lighter sentence in exchange for a guilty plea. Your attorney can help you weigh the pros and cons of accepting such a deal. 5. Court representation. If your case goes to trial, your attorney will represent you in court, presenting evidence, cross-examining witnesses, and making persuasive arguments to the judge or jury. An experienced attorney can create reasonable doubt and work to secure a favorable outcome. Contact a Colorado domestic violence attorney now. Facing domestic violence charges in Colorado is a serious matter with long-lasting consequences. A conviction can impact your job, relationships, and reputation. However, with the right legal strategy, it is possible to fight these charges and potentially get them dismissed. If you or someone you know is facing domestic violence charges, don't wait. Visit us at mcdowellfirm.com and book your attorney today. Also, please like and subscribe to our channel for more future updates. Thank you for watching and see you in the next one.